Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can the President of the United States declare martial law? The short answer is, it's incredibly complicated, and the Constitution doesn't just hand the President a button to press. Martial law is the temporary imposition of military rule over a civilian population, usually during a time of extreme emergency when the civilian government and courts can't function. This means military leaders are in charge, normal laws might be suspended, and civilian rights, like the right to a trial by jury, could be replaced by military justice. So let's break down where this power comes from, and more importantly, what the limits are. First, you won't find the phrase martial law in the President's job description in Article 2 of the Constitution. The Constitution does mention a related concept in Article 1, which is about Congress. It says the writ of habeas corpus, which protects you from unlawful detention, can be suspended in cases of rebellion or invasion. Notice that this power is listed under Congress, not the President. The President's authority primarily comes from their role as Commander-in-Chief of the Armed Forces and from laws passed by Congress, like the Insurrection Act of 1807. The Insurrection Act gives the President the authority to deploy troops within the United States to suppress a rebellion or enforce federal laws, but using troops to enforce laws is still different from completely replacing the entire civilian legal system. The biggest check on this power comes from the Supreme Court. After the Civil War, in a landmark case called Ex parte Milligan, the court made a crucial ruling. It said that military tribunals cannot be used to try civilians as long as the regular civilian courts are still open and operational. This is a massive barrier to a sweeping declaration of martial law. So, what's the bottom line? A president might attempt to declare martial law in a truly catastrophic scenario, like a foreign invasion or a total collapse of civil order where courts are literally unable to function. However, it is not an absolute power they can use to silence dissent or bypass the legal system. Any such declaration would face immediate and severe challenges in the courts, which have historically ruled that military rule cannot replace civilian justice when the courts are still open. The power is extremely limited, constitutionally ambiguous, and checked by both Congress and the Supreme Court. It remains one of the most extreme and legally contested actions a president could ever contemplate. Thanks so much for watching. If this breakdown helped you understand this complex topic, please consider liking this video and subscribing to the channel for more straightforward explanations of how our government works.